Good evening, everyone. I'm Dr. Brad Littlejohn, and I am a Senior Fellow of the Edmund Burke Foundation. I am very excited to welcome you all to this inaugural lecture of a new program here at the Edmund Burke Foundation, Foundations of National Conservatism. In these lectures, I and hopefully later on some of my colleagues will be sharing with you some fruits of the research we're doing into the deep historical and intellectual roots of the conservative tradition and the idea of the nation. Tonight's lecture is entitled The Common Law and the Rights of Englishmen, Medieval Foundations of American Liberty. I'm really grateful to all of you for taking time out of your busy schedules to join us for this inaugural lecture. Now, I'm going to talk for about an hour or so, and then we're going to take a 5-minute break and continue with then Q&A for about a half hour. So let's dive in. In America today, we live in a society that is rapidly losing its faith in the idea of the rule of law. We still care passionately about justice, but that's not quite the same thing. Viewed in the near term, after all, the law can appear to be one of the greatest obstacles to the achievement of real substantive justice. The law is a mechanism for delivering justice, but like any mechanism of great size, age, and complexity, it can be slow and creaky, mysterious in its operations, and imperfect in its results. Besides, the law does not encapsulate justice exactly as it is understood in any particular moment. Rather, it sums up the long, gradually evolving consensus of what justice demands, adapted over the centuries. By its nature, it serves to smooth out the rapid swings of popular sentiment from era to era, refusing to give any one generation everything that it wants, everything that in its youthful burning zeal for righteousness it thinks that it needs. Few generations in history, I would submit, have been so impatient for change, so revolutionary in their zeal to see justice done though the heavens may fall, as our own generation. This revolutionary fervor, while it may have started on the left, has spread increasingly across the political spectrum. Indeed, the ambition to overturn an election by force this January, in the face of unanimous opposition from the courts, was perhaps proof enough of how fully even the right has lost its allegiance to the idea of the rule of law. Indeed, even our thinking about the practice of law itself has become increasingly revolutionary. Partisans on both right and left still look expectantly to the courts, and above all to the Supreme Court, to carry out their aims. But what they look for is not the slow, frustrating, incremental reforms for which the judiciary is designed, but rather increasingly what people are looking for is social revolution by fiat, whether that be the wholesale redefinition of sexuality, or even, I would argue, the sudden overturning of a half century of abortion law by conservative judges. Now, in an older era, conservatives may have been apt to champion the judiciary precisely for its supposed resistance to change, its role as the bulwark of what was already established against the dangerous solvents of what might yet be. But such head-in-the-sand conservatism deserves much of the scorn that is heaped upon it by each passing generation, as its successive lines in the sand are dissolved by the shifting tides of history. The true role of the law, I would argue, and of its guardian, the judicial branch of government, is to serve as an instrument of durable change, of conservative reform, adapting in every age to the shifting needs of society without losing its grip on unchanging human nature or the precedents which alone can make change meaningful by weaving each new generation into the fabric of history. Now, although every legal system in some measure fulfills this role within society, I would argue that this account is particularly apt as a description of the distinctive legal tradition of the Anglophone world, the common law. A century and a half of globalization has certainly obscured the fault lines to some extent, but it remains the case that among the scores of national legal systems shaped by Western civilization, two very different legal families can be discerned. On the one hand, the English common law tradition, which still governs Great Britain, Canada, Australia, America, and other territories of the former British Empire. And on the other hand, the Roman civil law tradition, which predominates across continental Europe and former French and Spanish dominions, along with many other nations. Now, even within the modern United States, these divergent legal families have left their mark. We can see that 49 out of the 50 states have codes based on the common law, while Louisiana, a former French colony, follows the civil law. Now, both systems have their own pros and cons, and the partisans of each have lobbed insults at the other across the centuries. The civil lawyers have boasted of the superior clarity, rationality, and efficiency of their system, while the common lawyers have denounced it as an engine of despotism. Of course, both of them have a point. For the civil law, with its stress on written codes over unwritten custom, its focus on legislative enactment over judicial interpretation, and its emphasis on top-down centralization over bottom-up decision-making, is capable of doing greater good with less delay, but at the same time, it is also capable of doing greater evil. The defenders of the common law tradition, like the great 18th century legal historian William Blackstone, have acknowledged that common law judges might be stubborn, common law procedures arcane, and common law verdicts slow. But in part, by this very means, he argues, the common law has been one of the greatest bulwarks of liberty. Still, this stubbornness does not mean that the common law is incapable of reform. Indeed, by its very nature, the common law, arising out of custom and slowly developed precedent by precedent, with the input of the people themselves through its unique practice of trial by jury, was able to expand and mature from generation to generation. In tonight's lecture, what I hope to do is give you something of a whirlwind tour of 5 centuries of the English common law, from its medieval foundations to some of its important evolutions on the eve of the American Revolution. Now, of course, this is a huge story. Theodore Plucknett's concise history of the common law, which I highly commend to you, spans 850 pages, and William Holdsworth's much more thorough history of English law spans 16 volumes. So I'm just going to be focusing our attention on a few key figures and transition points. In the first section of this lecture, we will look at the common law's medieval foundations and Chief Justice Sir John Fortescue's famous In Praise of the Laws of England. Then, after a brief glance at the great Sir Edward Coke, spelled Coke if you've seen the name, Sir Edward Coke of the 17th century, we'll fast forward to the 18th century and focus on 2 key issues. The second main section will look at how the national common law was modernized to meet the growing demands of international trade, with Chief Justice Lord Mansfield playing a critical role in this transition. Finally, in the third section, we'll look at how Mansfield tackled the thorniest commercial question of all, the international slave trade. The common law's contribution to the global end of slavery provides a great test case for how law can serve as an instrument of conservative reform. So, with that roadmap in hand, let's go ahead and dive in. So first, medieval foundations. Ironically, given its later reputation as a bulwark against centralized power, the common law began life as Europe's first centralized national legal system, within Europe's first genuinely national state, which was medieval England. In fact, this role as a national law is the origin of its name. The common law was the law that was common to all of the king's courts in England, standing above the myriad local and regional customary laws administered by feudal lords in their manorial courts. Now, this irony is explained by the fact that England was blessed uniquely among all the nations of Europe by achieving a unified national state before either the theory of political absolutism or the means to make absolutism a reality had emerged, as they would do in the 15th through the 17th centuries. Thus, England was able to benefit from the advantages of political centralization, weakening oppressive feudal lords, giving widespread access to relatively impartial justice, and forming a common culture, without suffering from its despotic drawbacks. Indeed, by the time that absolutism reared its head in the England of the Stuarts, fueled by an ideology derived from France and the French civil law, the common law had developed such a robust identity of its own as an expression of the nation that was not quite part of the state, that England was able, alone of the great states of Europe, to resist the movement toward absolutism. During this 17th century struggle, the judges and advocates of the common law, led by perhaps the most famous common lawyer of all time, Sir Edward Coke, succeeded in limiting the monarchy itself under law and channeling the expansion of state power into the representative institutions of the House of Commons. Unlike the later Napoleonic Code, which abolished lower courts and established uniform justice throughout France by top-down fiat and ultimately military rule, the English common law gained its supremacy the good old-fashioned way: competition. Beginning in the decades following the Norman conquest, the Norman kings of England recognized the value of law as an instrument for knitting together their great island kingdom and preventing the feudal barons from reducing it to the near anarchy that prevailed throughout Europe, through much of Europe at that time. In particular, Henry II was a key figure in this transition. He reigned from 1152 to 1190. He was an administrative genius who probably deserves to be ranked alongside the greatest of English monarchs. During his reign, he established courts of justice in London, encouraged the development of a trained legal profession at the Inns of Court, and dispatched itinerant justices throughout the countryside, offering the king's justice to any who had grievances in need of redress. It didn't take long for Englishmen of lower and middle ranks to take them up on it. Not all feudal lords, to be sure, were petty tyrants, but they could hardly be expected to render impartial justice in their manorial courts when many suits involved the lord's own land and rights. And also, while local customs then as now had a certain rustic charm, they were also likely then as now to embody irrational prejudices that would harm certain members of the community. So the common law courts offered a more impartial justice. And indeed, simply by virtue of this superior justice, the common law courts rapidly gained market share, prestige, and authority throughout the 12th and 13th centuries. By the time of Edward I, litigants could even appeal the decisions of the manorial courts to the common law courts. Soon, feudal lords were effectively deprived of all criminal jurisdiction, and the idea took hold that the common law was not merely one law among several, but was the supreme law of the land. This remarkable achievement was attained in England centuries before her continental rivals, and it helped to foster one of the great blessings of the rule of law, which is to say, the liberty that comes from security and stability. I think nowadays we are apt to underrate this kind of liberty. And we don't realize how one of the great threats, we can think of overreaching law as a threat to liberty. But in fact, the absence of law is the greatest threat to liberty. The average 15th century Englishman might not have had that many rights by modern standards, but importantly, he knew exactly what his rights were. He knew where to appeal to have those rights enforced, and he knew that they were unlikely to change dramatically from one decade to the next. All of this was something that English law was able to offer much earlier than its continental rivals. Also, for all of the centralizing work of the common law courts, these rights were still by and large rooted in custom. The task of the common law judges, led by the great jurists Glanville, circa 1140 to 1190, and Bracton, circa 1210 to 1268, their task was not to promulgate new legislation, although the king certainly did some of this, particularly once Edward I developed the powerful representative institution of Parliament. But rather, the judges sought to clarify, synthesize, and purify existing customs. Thus, the common law drew its roots from the people at large. And although it was an instrument of consolidating royal power against the barons, it also functioned as a restraint on royal power. Now, this crucial political role of the common law was emphasized by perhaps the most famous of medieval common lawyers, Sir John Fortescue. Fortescue had the ill fortune to serve as Chief Justice of the King's Bench in the waning days of the House of Lancaster, as the incompetence of King Henry VI during the 1440s and 1450s helped provoke the bloody Wars of the Roses. Fortescue, for his part, loyally followed his inept but well-meaning royal master into exile in France, and then he served as tutor of Henry's ill-fated would-be heir, Prince Edward. Now, Fortescue had a front row seat of the importance of the rule of law during a time of ineffectual and divided executive authority. And he also, living in France, had a chance to compare and contrast England's legal institutions with those on the continent, influenced by Roman civil law. With this in mind, Fortescue composed his most famous work, In Praise of the Laws of England, in the 1460s. This book was written as a dialogue with his young royal pupil, and it proposes to investigate, quote, whether the laws of England deserve to be adjudged as fitting, effective, and convenient for this kingdom of England, as the civil laws are for the empire. He then goes on to summarize several contrasts between the common law and the civil law systems, and particularly emphasizes differences of English and continental legal procedure. Fortescue offers a sharp denunciation of the civil law's use of torture, quote, a practice that is not to be called a law, but a pathway to hell. And he also gives a famous account of the English system of trial by jury. Rather than being designed chiefly to secure condemnation of the guilty, says Fortescue, this English system is constructed as much as possible to secure the liberty of the subject against injustice and to protect the innocent. Fortescue concludes by asking, who then in England can die unjustly for a crime when he can have so many aids in favor of his life, and none save his neighbors, good and faithful men, against whom he has no manner of exception, can condemn him? I should indeed prefer 20 guilty men to escape death through mercy than one innocent to be condemned unjustly. Fortescue here highlights one of the chief glories of the common law, this institution of trial by jury. This is important because it introduced an element of popular representation into the judicial function of government. Now, the English cannot claim ultimate responsibility, ultimate credit for trial by jury. It was probably first devised by the Carolingian Frankish king Louis the Pious way back in the 9th century. However, for whatever reason, it never really caught on the continent. Instead, it came over with the Normans and the Norman conquest and took root in Norman England. There, it increasingly became a mainstay of the English common law system. Now, to be sure, trial by jury was no more immune to corruption than any other instrument of justice during this rough and tumble era of history. And over the centuries that followed, the frequent abuses of trial by jury, bribed or blackmailed juries, for instance, led to increasing restrictions on the practice. However, the institution endured, and by the early modern period, it became a powerful built-in mechanism for legal reform. Whenever royally appointed judges sought to crack down on political dissent, or the laws became hopelessly out of touch with changing circumstances, the juries were able to give this level of popular input into the legal process, preventing it from being a purely top-down thing. Now, in addition to praising the institution of trial by jury, Fortescue rejoiced that the people of England were not merely protected in their lives against unjust condemnation, but also in their properties against unjust seizure, even by the king himself, who, quote, cannot despoil any of his subjects of any of their goods without due satisfaction for them. Nor can the king there, by himself or by his ministers, impose tallages, subsidies, or any other burdens whatsoever on his subjects, nor change their laws, nor make new ones, without the concession or assent of his whole realm expressed in his parliament. For this reason, argues Fortescue, the people of England enjoy a security and prosperity that is unparalleled on the continent, and especially in France, where Fortescue sees that absolute royal power was grinding the peasants into perpetual poverty. Now, following this account by Fortescue in the dialogue, the prince exclaims, I wonder very much why this law of England, so fitting and so desirable, is not common to all the world. Fortescue responds by drawing a clear line between patriotic pride in England's national laws and imperialistic hubris that would try to see these laws applied everywhere. Fortescue says the common law is the best for England, but this is the result of particular economic, geographic, and demographic advantages, such that he says it would be impractical to try and apply it to other realms. Indeed, what is particularly striking in Fortescue's recognition, what's particularly striking is Fortescue's recognition that liberty and prosperity form a virtuous circle. Good governance has created a situation in which the people of England are more prosperous and self-governing. And precisely for this reason, it is more feasible for English institutions to involve the citizens in legal decision-making, such as trial by jury, and political decision-making, Parliament. The French peasantry, Fortescue observes, are hardly in a position to exercise such forms of self-rule. Now, to be sure, an experienced judge like Fortescue could hardly have been unaware that his rosy portrait of English law and legal practice often bore little enough resemblance to the realities of delayed justice, corrupt juries, and cunning barristers who bent the law to serve the interests of powerful clients. It is likely that, like many patriotic would-be reformers, Fortescue deliberately offered an idealized account as a vision of what English law could and should be, a vision that he hoped his royal pupil would imitate should he ever come to the throne. But still, this is part of Fortescue's point about the virtues of English institutions. They are self-correcting, capable of constant improvement whenever they are found unsuitable to the needs of the people. Still, I think there's obviously a tension here. Was the glory of the common law its hallowing of immemorial custom or its openness to change? Was it an instrument of conservatism or progressivism? Now, the answer, I think, is surely both. Or rather, we would say that it was an instrument of authentic rather than merely reactionary conservatism. Russell Kirk notes in The Conservative Mind, quote, "Slow change is the means of conservation, like the human body's perpetual renewal." At key points in English history, the common lawyers successfully innovated in response to fresh challenges, but they ensured that these innovations would come wrapped in the sanctity of the past, bolstered by the authority of tradition. Perhaps the most famous such episode was the 17th century showdown between the Stuart monarchs and the great parliamentarian Sir Edward Coke, perhaps the most learned common lawyer of all time. Now, Coke was the leading author of the 1628 Petition of Right, which is the most important statement of English liberty since Magna Carta. And he helped lay the foundations for the emergence of parliamentary sovereignty. He was also among the most erudite scholars of the medieval common law that have ever lived. So much a master of this arcane literature that later generations of lawyers used his works as authoritative textbooks of English law. And it was precisely from this respect for tradition that he drew his commitment to reform, declaring, "Let us now peruse our ancient authors, for out of the old fields must come the new corn." T.F. Plucknett writes, quote, "So it was in this spirit that he labored at the ancient patrimony of his profession, those short, thick folios of black-letter yearbooks, and from their forbidding mass of obsolescent technicalities raised a harvest of political theory which was destined to be the food of far distant states to which he had never given a thought." However, since the age of Coke is very much the expertise of my Edmund Burke colleague Ophir Haivry, and he might be giving a future lecture on it, I'm going to skip on from this period to skip on from the tumultuous 17th century to the outwardly sleepy 18th century. A century that was in fact to witness very important changes in English law under one of the most famous of all judges to sit on an English bench, Lord Chief Justice Mansfield. It also saw the most famous of English legal writers, his younger contemporary, Sir William Blackstone. The 18th century also offers some excellent case studies of this idea of conservative reform, testing whether or not the archaic medieval common law really could be flexible enough to serve the needs of a modern commercial society. So, Section 2, National Law and International Trade, Entering the Modern World. By the mid 18th century, one of the most important classes of society was that of the merchants. Indeed, since England had begun to establish global naval dominance in the late 1600s, together with a collection of prospering colonies, English society was undergoing rapid economic transformation, especially following the union with Scotland in 1707. The old agricultural economy, built on subsistence and limited internal trade, had given way to a commercial economy with accelerating international trade and a growing domestic industrial base. This social transformation placed increasing strains on the old wineskins of the common law, which had developed in an era when the only wealth that mattered was that of land, and almost the only important economic relationships were those of landlord and tenant. Although land could be bought and sold, by far its most common form of transmission was by inheritance. Thus, the common law administered a social order that was designed for stability and stasis, not growth and dynamism. Contract law was minimal, and notions of liability, insurance, and bankruptcy, which were essential legal concepts within the growing commercial society, were even more underdeveloped. Now, here, the early centralization of English law had proven a hindrance. Elsewhere in Europe over the preceding centuries, it was also true that ordinary law was designed for a hierarchical agricultural society. But parallel legal systems had flourished to serve other classes of society. Foremost among these was the mercantile law, which developed rapidly in medieval Italy, which was then the hub of international trade. The merchant law, however, was in most Mediterranean lands, it was something of a law unto itself. The merchant guilds despised the tedious debates and technical distinctions of lawyers who could hardly be expected to understand the business of trade. And so they developed their own tribunals with their own judges and their own legal customs. To the extent that lawyers did have to get involved, they came to work within courts and according to legal rules that were totally separate from those which governed the local landed societies. So you had these parallel legal systems, parallel courts developing. Now, in England, the early dominance of the common law was unfriendly to this kind of autonomous development. And so mercantile practices tended to occupy a tenuous position on the margins of the law. Now, in medieval times, when the island nation itself occupied a tenuous position on the margins of European trade, this didn't matter much. But when England found itself increasingly at the center of the transatlantic trade, it was clear that the merchant law was in dire need of development. The initial vehicle for this development was the High Court of Admiralty, administered on behalf of the Crown by the Lord High Admiral of England. This claimed jurisdiction over any business transacted on the seven seas. However, because of its dependence on the Crown, the Admiralty Court was not so reliable as a guarantor of English liberties as the common law courts had been. Importantly, it lacked the crucial practice of trial by jury, and it was thus subject to frequent abuses. As the common law gained additional confidence following the ouster of the Stuarts and the defeat of absolutism in 1688, the assimilation of the merchant law became one of the chief priorities of the common lawyers. Now, this process was initiated by Chief Justice Holt in the 1690s, but it reached its climax during the legendary tenure of William Murray, Earl of Mansfield, who was Chief Justice of the King's Bench for a remarkable 32 years, from 1754 to 1786. Recognized as one of the greatest judges ever to sit on an English bench, Mansfield's decades of reform forged the once rigid frame of the common law into a powerful and flexible instrument that could administer justice throughout the greatest commercial empire the world had ever seen, and would also serve as a foundation for the laws of the new American nation. Whereas common law judges tended to concentrate their erudition within the narrow stream of their own jurisprudence, Mansfield read widely and deeply across the legal literature of Roman law and contemporary Europe. Mansfield remembered that the original success of the common law had come from competition, and he worried that it was now that it achieved dominance, it had ossified and fallen prey to a form of corrupt national pride that was uninterested in learning the practices of other nations. Mansfield thus determined to restore the common law to fighting trim by insisting that precedents must not become self-justifying. Legal precedents had to express moral principles, and moral principles should be given concrete shape in the form of legal precedents. By this means, declared Mansfield, the common law, quote, works itself pure by rules drawn from the fountain of justice. The judiciary, Mansfield believed, could function both as a bulwark of stability and as an engine of responsible change. Nowhere was this more the case than in Mansfield's treatment of the law merchant. Just as the common law had originated in local custom, Mansfield resolved to integrate the customs of the merchant community into the common law by impaneling special juries drawn from within the merchant community to help decide cases of mercantile law. Now, by this means, he was able to square a circle that had bedeviled the mercantile law for centuries. He enabled merchants, as those most likely to understand their own complex transactions, to have a say in their own disputes, while also ensuring that these litigants enjoyed the liberties afforded by the common law. Chief Justice Holt had already pioneered this technique, but Mansfield's consistent application of it over decades succeeded in assimilating isolated precedents and mercantile customs into general principles of common law. Such merchant juries were particularly useful when in cases involving the burgeoning insurance industry, where it was critical to determine which risks could be reasonably anticipated and which could not, which accidents could be fairly attributed to the negligence of a merchant or ship captain, and which ones were simply acts of God. An even more difficult question involved coming up with a fair estimation of expected profits on lost merchandise that had been insured. So in the landmark case Lewis versus Rucker in 1761, Mansfield relied on a special jury of merchants to fix the sum owed by an insurer, stating they understood the question very well and knew more of the subject of it than anybody else present, and formed their judgment from their own notions and experience. Insurance was indeed one branch of law where Mansfield left his permanent stamp, seeking to ground precedent on firm moral principle in an area that was notoriously susceptible to fraud. On the one hand, he came down hard on all forms of fraud or material misrepresentation, by which insured parties sought to conceal significant risks from insurers. On the other hand, he recognized the temptation of underwriters to hide behind any excuse to avoid paying out, even in the case of foreseeable risks. In another landmark case, Carter versus Boehm in 1766, Mansfield defined the scope of insurer's liability for centuries to come. Quote, the insured need not mention what the underwriter ought to know. This case concerned an insurance policy on Fort Marlborough in Sumatra, which had fallen to French attack. Although the underwriters sought to avoid paying out by contending that they had not been informed that the fort was highly vulnerable to enemy attack, Mansfield found that this risk was public knowledge to anyone who sought to inform himself, and thus the insurers must be assumed to have taken responsibility for it. This risk was general knowledge, and therefore the underwriters must be assumed to have taken responsibility for it. Now, in general, Mansfield's goal was to ensure that neither party to a contract was able to take refuge from his moral obligations by hiding behind legal technicalities. So some of his boldest reforms came in the area of contract law, which was in a very confused state during his time. In Blackstone's commentaries, we see this, where different sorts of contract are scattered throughout with no systematic account of the essence of contract. In one of his clearest pronouncements on the subject, Blackstone stated the received doctrine of the common law up to his time, saying, a consideration of some sort or other is so absolutely necessary to the forming of a contract that a nudum pactum, that is, an agreement to do or pay anything on one side without any compensation on the other, is totally void in law, and a man cannot be compelled to perform it. Consideration was so fundamental to English contract suits that unless a plaintiff could show that he himself had given or pledged some tangible benefit in the contract, there was no way to hold the defendant responsible to fulfill his promise. Mansfield was not so sure. After all, what was a contract but a promise? And what legal principle was more fundamental than pacta sunt servanda, promises must be kept? Thus, in one of his boldest rulings as Chief Justice, Pilons versus Van Mierop of 1765, Mansfield argued that consideration merely provided crucial evidence that a contract existed, but did not itself constitute the contract. If the court found other evidence that one party had made a promise and the other had relied upon it, a contract could be construed as being in force. Now, Mansfield was aware that this was a departure from established legal practice, but he was convinced that this practice was the outmoded relic of a time when lack of written documentation made proof of contracts very difficult. Commenting on the Pilons case, T.F. Plucknett observes, Mansfield sought to use history itself to liberate law from its historical fetters. Now, although the Pilons decision was later partially reversed by the House of Lords as too radical reform, still, together with other Mansfield cases, it laid the groundwork for later developments in Anglo-American contract law that made it easier for merchants and all citizens to establish and enforce their agreements. But it also signaled Mansfield's belief that the law was supposed to be an instrument of morality, and that a contract, the goal in determining what a valid contract was the moral obligation. And this is going to be important when we turn to the question of slavery. The greatest significance of these decisions was the fact that Mansfield insisted on handling them within the common law courts. This meant, according to Sir William Holdsworth, that in England alone among the nations of Europe, commercial and maritime law became simply a branch of the ordinary law. The result was no mere addition to the common law, but a pervasive transformation as principles and procedures originally devised for a static agricultural society were reshaped to encourage freedom of contract and exchange. This new jurisprudence was able to prove its mettle over the succeeding century, presiding over the greatest economic expansion in the history of the world as Britain leapt to global dominance and America soon followed in her footsteps. Throughout this rapid economic transformation, the common law was able to demonstrate its remarkable ability to adapt to changing conditions. However, there was at least one dark cloud on this otherwise sunny maritime horizon, arising from a particularly troubling mercantile custom and form of contract, which was slavery. So, in this last section, we're going to look at a law so favorable to liberty, the common law's triumph over slavery. Now, popular historiography today often sees slavery as a medieval holdover from the Dark Ages, and it credits the radical Enlightenment with getting rid of it. However, the opposite is nearer to being the case. In its starkest form of chattel slavery, indeed, in which a human being is reduced to mere movable property, lacking any rights vis-a-vis other human beings, slavery was almost unknown in medieval Europe, and certainly in England. Serfdom, or villeinage, as it came to be known in English law, was more a matter of the status of land than of persons. A villain was bound to a certain piece of land which belonged to the Lord, and was forced to render service on it. However, by the influence of the church, the villain was still and was increasingly considered a legal person with certain protections vis-a-vis his master and others. Now, the common law aided this process of giving the villain legal rights in the 2 centuries following the Norman conquest. Holdsworth writes, quote, "The growth of the common law was unfavorable to the existence of a class of slaves. The crown protected the life and limb of all its subjects, and so we find that the distinction between free and unfree had little application in the criminal law. By the time of Bracton, in the mid-1200s, serfs still existed, but only in the sense that they were bound to serve their landlord. Unlike earlier Roman or later Southern American slaves, they possessed toward all other parties, quote, all or nearly all the rights of a freeman. So, for instance, an English serf could expect protection from his person and property in court like other men, and could even serve on a jury. A few decades later, in the 1300s, Chief Justice Hurrell would declare, "In the beginning, every man in the world was free, and the law is so favorable to liberty that he who is once found free in a court that bears record shall be holden free forever, unless it be that some later act of his own makes him villain." Even if he were a villain, by this time he was often able to gain his freedom simply by running away. The common law would protect him against recapture unless he then returned to the manor. So again, the bondage was more an attachment to the land rather than the lord's personal ownership of the serf, the villain. Now, the Black Death contributed further to the emancipation of serfs by inducing an acute shortage of labor. Plucknett writes, lords of manors who could no longer find servile labor either leased their lands to free laborers, or to laborers who were soon to become free, or else tacitly conceded to their peasants the benefits of ownership in their holdings. This latter process is truly remarkable and deserves close attention from students of legal history. Through the machinery of custom, which was always a powerful influence for experiment or change in the Middle Ages, the rightless villain slowly acquired customary property rights in the land he worked. In this way, those sweeping and violent social revolutions which occurred in Switzerland and France were avoided in English history through the slow adaptation of the law to new social conditions, no doubt assisted by the lack of a precise definition of property. While the willingness to tolerate for a time a few anomalies helped to accomplish by peaceful means the great task of transforming the ancient serfdom into a class of free workers. By Tudor times, so well established had the common law's protection of liberty become that William Harrison could write in his 1577 description of England that there were no slaves in England, and, quote, if any come hither from other realms, so soon as they set foot on land, they become as free in condition as their masters. Unfortunately, however, this was to be the high watermark of the cause of freedom in England for more than 2 centuries. Even as Harrison wrote, English merchants were joining the Italians, Spanish, and Portuguese in penetrating the ports of the Dark Continent and exchanging their European goods for African bodies. Against this soon nearly universal mercantile custom, the English common law was unsure at first how to proceed. After all, despite the growing reach of British trade and British military power, the common law had never claimed any jurisdiction outside of England. It was an English national law. And if slavery was permitted in foreign parts, what was to keep an otherwise honest merchant from bringing his slaves with him to England? And if he subsequently sold them, would the courts dare to nullify this contract? In 1677, the Court of King's Bench held in Butts versus Penry that the courts would not nullify such a contract, and that the owner of a Negro slave could take legal action to recover his escaped or stolen property. However, 30 years later, Chief Justice Holt overruled this decision and stated in Smith versus Gold that, quote, by the common law, no man can have a property in another. However, Holt's verdict provided no mechanism by which a slave could sue for his freedom, and thus the situation remained legally murky throughout the following decades. Indeed, Attorney General Philip York contradicted Holt's judgment in a 1729 opinion. We can see this ambiguity about slavery in Blackstone's famous Commentaries on the Laws of England. In the first edition of 1765, Blackstone appears to side with Holt. And he writes in his discussion of the absolute rights of individuals at the very outset of his treatise that, quote, this spirit of liberty is so deeply implanted in our Constitution and rooted even in our very soil that a slave or Negro, the moment he lands in England, falls under the protection of the laws, and with regard to all natural rights, becomes from that instant a freeman. However, in later editions, he added the ambiguous proviso, though the master's right to his service may possibly still continue. Now, this proviso was likely in response to critical feedback, which pointed out a possible contradiction with his discussion of master and servant in Book 1, Chapter 14. There, he initially says a slave or Negro, the instant he lands in England, becomes a free man. That is, the law will protect him in the enjoyment of his person and his property. But he adds, yet with regard to any right which the master may have lawfully acquired to the perpetual service of John or Thomas, this will remain exactly in the same state as before. For this is no more than the same state of subjection for life, which every apprentice submits to for the space of 7 years. Now, what's going on here is that Blackstone is seeking to distinguish between chattel slavery, which he thoroughly repudiates in line with common law principles, and on the other hand, a contract of perpetual servitude, which he concedes to be at least legally possible, at least if it was contracted originally outside of England. Now, in the former, the situation of chattel slavery, the slave is personally treated as a mere extension of the master's property. He has no legal rights. In the latter, the slave's labor is pledged to his master, and his freedom of movement is forfeited, but his legal status is otherwise the same as that of a free man. Now, and Blackstone thinks that latter is definitely the case under English common law. Now, he and many English judges had their doubts as to whether slavery was valid in any form, but until a slave could find clear grounds to sue for freedom, the status quo favored the rights of masters. And by 1771, English masters held around 15,000 black slaves within England. However, that year marked a crucial turning point, as the evangelical anti-slavery activist Grenville Sharp finally found his cause célèbre, Somerset versus Stuart. This became one of the most famous cases in English common law history. Now, the story was that Charles Stuart, a Scottish merchant, had acquired a black slave named James Somerset in Virginia, and he brought him back to England in 1769. Through the agency of some of Sharp's abolitionist activists, Somerset was baptized in August 1771. Now, this was important because it undermined a common justification for African slavery, which was that since the heathen Africans practiced slavery amongst themselves, the laws of Christian nations and of Christian Englishmen would not apply to them. Now Somerset is baptized, which means he should be treated like a Christian Englishman. Now, afterwards, Somerset escaped, but he was soon recaptured, and Stuart imprisoned him aboard the ship Anne and Mary, from whence he planned to take him to Jamaica and sell him in the slave market. On December 3rd, however, Somerset's godparents petitioned Lord Mansfield for a writ of habeas corpus, requiring Stuart to show just cause for his deportation. Now, the writ of habeas corpus had originated as a protection against unjust imprisonment. But in 1682, it had been expanded by the landmark Habeas Corpus Act to also protect English subjects against deportation without just cause. Grenville Sharp and his lawyers contended this was exactly what Stuart was doing to the king's subject, James Somerset, imprisoning him without cause aboard a ship bound for the West Indies. The implications of this case were potentially momentous. If the Court of King's Bench ruled against Stuart, it would amount to a declaration that no slave could be held against his will within the jurisdiction of England. Thus, it would mark an effective abolition of slavery within the island. Lord Mansfield recognized the weight of this issue, and he was torn between his sense of the moral repugnance of slavery, on the one hand, and his regard for the sanctity of contract and his habit of deferring to mercantile custom on the other. Indeed, with his conservative temperament, Mansfield worried about the socioeconomic consequences of mass emancipation. So initially, he sought to have the case settled out of court. He repeatedly urged the obstinate Stuart to render the case moot by just manumitting Somerset. But Stuart wouldn't have it. Indeed, both the merchants and the abolitionists dug in their heels, hoping for a showdown. And Mansfield ultimately realized that he was going to have to give judgment one way or the other. On June 22nd, 1772, Mansfield announced the unanimous verdict of the court to a crowded courtroom. Quote, "The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political. It is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences, therefore, may follow from a decision, I cannot say this case is allowed or approved by the law of England, and therefore the black must be discharged." Now, this ruling was narrow enough. Note that Mansfield had not pronounced slavery invalid in every time and place, however odious it was, nor had he sought to outlaw it throughout the British Empire. He had not even declared in so many words that it was illegal in England. What he had said, with consummate lawyerly skill, was that it was not positively legal in England, And thus, since the writ of habeas corpus placed the burden of proof on Stuart to show that he had just cause to detain and deport Somerset, Stuart could not do so, and Somerset was free to go his way. Thus, the case did not result in a mass emancipation throughout the British Isles, much less did it alter the legal status of slaves in the colonies. However, it was still momentous enough. Abolitionists felt that the tide had clearly shifted in their favor, and that the common law's commitment to liberty would in due course triumph over the forces of greed that were gaining a footing elsewhere in the empire. Other British judges began to build on the Somerset precedent. Most notable among these was the Knight case in Scotland of 1777. Joseph Knight was an African-born slave, but he was an educated one. He actually read about the Somerset case in the newspapers when the decision was handed down, and he drew his own conclusion from it. He was a free man, so he demanded his wages. His master refused, and he ran away. The resulting case dragged through the courts for 5 years before final appeal to the highest bench in Scotland, where Mansfield's friend, the great jurist Lord Kames, helped write the verdict. Quote, "The dominion assumed over the Negro under the law of Jamaica, being unjust, could not be supported in this country to any extent." Now, this decision was much broader than the Somerset one, and together with subsequent cases, it meant that when the zealous reformer William Wilberforce embarked on his great campaign in Parliament against the slave trade in the 1780s, Wilberforce was able to claim to be on the side of law rather than revolution. It still took time, of course. The abolition of the slave trade in the British Empire did not come until 1807, and slavery itself was not altogether abolished until 1833. But when this change came, it stayed. Unlike the short-lived French legislation ending slavery in the heady days of the Revolution in 1794. This French legislation, like the seed in Christ's parable of the sower, sprung up quickly in rocky soil, but then withered in the hot sun, whereas the British Abolition Acts took deep root in the long-plowed soil of the common law and bore fruit in the spread of emancipation, led by Britain's example throughout the whole globe. So, conclusion. The old Gothic castle and the genius of conservative reform. There's a famous passage of Blackstone's commentaries where, as a lifelong architectural enthusiast, he memorably compared the English common law to an old Gothic castle. Reflecting on the gradual work of the common law judges in refashioning old feudal forms of legal remedies to suit the needs of modern property, Blackstone applauds them for refusing to solicit, quote, any great legislative revolution in the old established forms, which might have been productive of consequences more numerous and extensive than the most penetrating genius could foresee. Instead of comprehensive reforming legislation, they resorted to minute contrivances that now, quote, refined by the practice of more than a century, in general answer the purpose of doing speedy and substantial justice, much better than could now be effected by any great fundamental alterations. Our system of remedial law resembles an old Gothic castle erected in the days of chivalry, but fitted up for a modern inhabitant. Excuse me. The moated ramparts, the embattled towers, and the trophied halls are magnificent and venerable, but useless. The inferior apartments, now converted into rooms of convenience, are cheerful and commodious, although their approaches are winding and difficult. In this, deems Blackstone, lies the glory of the common law. Now, many would-be reformers in that day and this would no doubt prefer to pull down the useless old castle and build a fine modern country house in its stead. They would prefer to replace the obsolete forms of medieval law with a rational, enlightened, and thoroughly up-to-date legal code. This is what the legislators of the French Revolution were up to, and this is also what the young firebrand Jeremy Bentham sought to do. He sat impatiently through Blackstone's lectures in 1764 and spent the rest of his life denouncing the conservatism of the common law. In 1811, Bentham, despairing that his own country would ever listen to his radical reforms, wrote to President James Madison, offering to write a comprehensive liberal law code for the young American Republic. Madison wisely refused, and instead, American law took shape under the steady hand of John Marshall, a great admirer of both Blackstone and Mansfield. Probably the admiration would have been mutual. Although neither Blackstone nor Mansfield lived to see Marshall's tenure on the Supreme Court, Lord Mansfield, after presiding over the King's Bench into his 80s, kept his mind sharp by reading the latest legal decisions. A few weeks before his death in 1793, a visitor to his country home found him, quote, reading some causes heard before Chief Justice of the United States, which at this time was John Jay. Mansfield remarked to the visitor that of the whole number of the volume, there was not above one or two that he should have decided otherwise. Indeed, this is hardly surprising, for the common law provided a common bond which knit together the two great English-speaking nations from their earliest days of America. Writing several decades later, the great American jurist Joseph Story said of the common law, "It became the guardian of the colonists' civil and political rights. It protected their infant liberties. It watched over their mature growth. It expanded with their wants. It nourished in them that spirit of independence. And by the good providence of God, we, their descendants, are now enjoying, under its bold and manly principles, the blessings of a free and enlightened administration of public justice." American law, like the English law before it, would proceed by incremental reform from within, as judges in each new era sought to derive principles from precedents and tweak the law to meet new challenges. They refused the temptation to achieve a more perfect ideal of justice by making a clean slate. Much safer than the wholesale reconstructions of idealistic legal bulldozers, reasoned Blackstone, were the slow, step-by-step renovations of those who actually lived in the castle and knew its every inch. In this metaphor, the common law judges. They knew how to build on old foundations and put forgotten passageways to new uses. By this means, the edifice could be adapted to the needs of each new generation without losing the connection to the past that secured the loyalty of its inhabitants. In their own time and since, both Blackstone and Mansfield were often maligned by progressives for being bootlickers of the powerful, apologists for long entrenched injustices whose time was now up. There's no doubt that with the benefit of hindsight, we can identify areas in which they were, as all of us are, blind to injustices perpetrated under the authority of law, and that both of them missed opportunities for much needed reform. Still, their full record shows that both men were liberal-minded lovers of justice, eager to see liberty expanded where it was compatible with social order and the public good. And both men understood that the English judiciary, with its reverence for precedent and its modest dose of democracy in the form of juries, was uniquely positioned to serve as a tool for nurturing the sustainable growth of liberty. By balancing respect for precedent with the freedom of judges to creatively adapt that precedent to solve new problems, the common law placed the wisdom of past and present into creative dialogue. By inviting the people themselves to give voice to evolving customs and moral sensibilities through their verdicts as jurors, the common law ensured the law would not become a dead letter, but depended on the continuing agency of each generation to remain effectual and relevant. Blackstone's and Mansfield's reforming jurisprudence is still regularly cited today wherever the common law holds sway. So the old Gothic castle, though now fitted out with modern lighting and plumbing, can still provide comfort and security to all those who shelter within its walls.